Welcome back to the channel. Now, some people have said this is one of the reasons why the Court of Appeal has found it impossible to grant a retrial against Vybz Kartel and the other co-accused. Now, his attorney John Clark disclosed that the prosecution has only accounted for 16 pieces of evidence, when based on transcripts from the trial, there should be 25 exhibits in total, with the rest of them there. Let me say among the evidence not re-verified is the signature of the main eyewitness. Of course, we're making away from Miss Jackson Miller, as she has been following the case, and then we are continuing reasoning. Look and listen.
From 2012 murder, his matter had been sent back to the Supreme Court in September 22. You had another case. The second case was Rashawn Hamilton. He had been convicted of a 2008 murder, and his matter had been sent back to the Supreme Court in September 2023. In neither of these cases has a retrial taken place. A retrial date, in fact, has not even been set. The court also said that for judge alone trials, that's where you don't have a jury, the dates are now being set for late 2025. For jury trials, the dates now are being set for late 2026. But the Supreme Court said, hold on, we also do have a system where we can give a case priority attention, meaning it would be fast-tracked if the circumstances required. So that does suggest that there is this possibility that if the cartel case is sent for retrial, it could be put on a priority list and therefore, heard at a relatively early date. All right, let me come back to the issue of bail now. So remember, what I've said so far is that the prosecutor has said that one possible way of dealing with a possible breach of a constitutional right to a trial within a reasonable time is the grant of bail. Grant of bail also came up as a possible remedy in relation to this idea of the ordeal the men have suffered. Remember, we spoke about the reports, the medical reports that have been submitted on behalf of Vybz Kartel, how he's suffering physically, his physical health has declined, his emotional health has declined, his mental health, and the other men also have filed affidavits speaking to the way in which they're being affected. And again, the prosecutor said one possible remedy to deal with this is bail. So bail is there now on the table. The court is being said, prosecutors are saying to the court is, look, this matter should only be thrown out as an absolute last resort, but you don't need to go there because here are some options that are available to you. Okay, so there's another point that the prosecution made that I thought was such an important and interesting point, and it had to do with the publicity issue. So remember, the lawyers for the accused men have been arguing that there's just so much publicity in this case. So recap of day 5 in the Court of Appeal hearing as to whether Vybz Kartel and his co-accused should get a retrial. So what happened today? Again, it was an interesting day. I thought the prosecutors made some really interesting points. And let's start with this issue of how bail came up. Now, lawyers for the accused persons, as I mentioned in my previous videos, they have been making some very strong arguments that a retrial would end up by causing violations to the constitutional rights of Kartel and his co-accused. One of those rights that there's a lot of focus on is the issue of delay. Would the men be able to get a fair trial within a reasonable time? Remember, they've been in custody now since 2011. If there's going to be a retrial, we're talking about another couple of years more than likely. Will their constitutional right to a fair trial in a reasonable time be breached? Now, today, the prosecutor who was addressing the court on that matter said, look, we accept that if the matter goes for a retrial, it's likely that their right to a hearing within a reasonable time is going to be breached. So her position was to start out by saying we're not trying to argue that. She did say, however, her very strong argument then was that, look, we, however, believe that if there's going to be a breach of a constitutional right like this, the right to a fair trial within a reasonable time, what you then have to do, the next step has to be, what is the remedy to deal with that breach? Because she said the idea of throwing out a case, of dismissing a case because of delay has to be a last resort because it's in the public interest that this retrial takes place. So therefore, you want to look at possible remedies. how could you respond to this issue of the delay in the case? And two of the remedies that she suggested, one were the idea of an expedited hearing, meaning put the retrial on the court list as a matter of priority so it happens quickly rather than having the men then again having to wait years for the second trial. And the second possible remedy she mentioned was that of bail. I should say that this whole idea of a priority hearing had actually been mentioned at the beginning of the hearing when the presiding judge said she had got from the court, the Supreme Court rather, the list that the Court of Appeal had asked for. The Court of Appeal had asked the Supreme Court to send a list of all the cases that the Court of Appeal had sent back for retrial in the past 6 years, and the status of those dates are now being set for late 2025. For jury trials, the dates now are being set for late 2026. But the Supreme Court said, hold on, we also do have a system where we can give a case priority attention, meaning it will be fast-tracked if the circumstances required. So that does suggest that there is this possibility that if the cartel case is sent for retrial, it could be put on a priority list and therefore, heard at a relatively early date. All right, let me come back to the issue of bail now. So remember, what I've said so far is that the prosecutor has said that one possible way of dealing with a possible breach of a constitutional right to a trial within a reasonable time is the grant of bail. Grant of bail also came up as a possible remedy in relation to this idea of the ordeal the men have suffered. Remember, we spoke about the reports, the medical reports that have been submitted on behalf of Vybz Kartel, how he's suffering physically, his physical health has declined, his emotional health has declined, his mental health, and the other men also have filed affidavits speaking to the way in which they're being affected. And again, the prosecutor said one possible remedy to deal with this is bail. So bail is there now on the table. The court is being said, prosecutors are saying to the court is, look, this matter should only be thrown out as an absolute last resort, but you don't need to go there because here are some options that are available to you. Okay, so there's another point that the prosecution made that I thought was such an important and interesting point, and it had to do with the publicity issue. So remember, the lawyers for the accused men have been arguing that there's just so much publicity in this case.
And it's handwritten statement taken by the police. Remember, prosecutors have stated that if there's a retrial, they more have to use witnesses, and them say them locate most of the witnesses, but them now have this piece of evidence. So he was quoted as saying, on the face of the record before the court, it seems there's an issue to be resolved because in Miss Laura Green's affidavits, after she indicated and said, so as a result, he was quoted as saying, he caused a check or checks to be made on the file. And based on his review, a total of 16 exhibits were tendered in the matter. He also caused a check to be conducted of the secure area where the exhibits are stored, and it was found that only 16 exhibits are accounted for. So even when them check where the evidence is being kept, only 16 there. He was also quoted as saying, it is apparent in the affidavit on record that what the DPP has presented to us as the verification of all the exhibits from Miss Green, he believes there's still some more work to be done with even their presentation, much less if there is a retrial granted. He further explained that the Supreme Court Registrar Laura Green had indicated in her affidavit of re-verification that all the exhibits in the matter were in a secure area, and based on the request from the Director of Public Prosecution, had made the necessary checks and certified exhibits up to 16, so only 16 were available. Consequently, he pointed out that the prosecution, in its argument about the strength of its case, must consider the exhibits which are accounted for. So even though the prosecutors were saying that they had a strong case, and that regardless of what was being said by the defense, them have enough to go forward with the case. Basically, the defense is saying that them not have enough evidence to say that. because the 25 that was used in the trial, only 16 them have left. Where the rest there, nobody no know. No continuing further. He raised the matter of exhibits and also raised concerns about the possible retrial and exhibits which have already been leaked to the public. He was quoted as saying, "We agree entirely with the Crown's submission that mere adverse publicity is not enough for an adverse position." But he said, "What we are concerned about is not the publicity. What we are concerned about is the prejudice of such a degree in relation to the contents, and that would jury tampering and link between the accused men and the leaked material. These are more of the concerns of the defense." Tell me what you think. Now, the acting DPP, Claudette Thompson, during an earlier submission, had indicated that even without the technological material, which includes digital and communication evidence, the Crown would still have an objectively strong case with the direct evidence that it has. But they look like they might not have all the direct evidence. Her argument followed the indication from the defense that it would be challenging the use of some of the technological material in the matter is retried, or if the matter is retried. And think about it. The defense now have added evidence from the digital forensic expert that did look over that evidence there. So I guess the prosecution already has said, all right, if the new evidence that was found on those are relating to that technological find, if it is now more beneficial to the defense than the prosecution, and them not need to use that, or them choose not to use that, them still have other things that make the case strong. No exhibits missing. Them only have 16 out of the 20 that them supposed to have. Is there any other parts or things that them plan to use in the trial also missing? Them sure them have everything what them need? Because it's almost as if they were not aware, say, those 16 are the thing them left back until them did ready to use them at the moment. Then them realize, say, oh, wait, some of them gone. Talk to me in the comment section. Tell me what you think. Do you think the prosecution has the case for them say them have? Or just because at the prosecution job for prosecute and them must do them job? Do you believe that them still try to carry out the wishes of the former DPP as a way to prove themselves that, you know, they are capable of leading the office forward even in her absence? Do you think that the defense has presented a stronger case to the Court of Appeal, and that even though it's the three-judge tribunal's job to question everything being presented by both the defense and the prosecution, but do you believe that when questions were asked by the judge to the prosecution was more unequipped with answers, or the answers that were given were not favorable to their plight? And do you believe that the defense made a stronger submission, and even when questions were presented to them, their answers were more fitting? Do you believe that the court is willing to commit resources to a retrial? Talk to me. But with evidence missing, it don't seem like the prosecution have a strong enough case. Some would say. But talk to me in the comment section. If you're new to the channel, pass through, click the subscribe icon and then the bell icon. And of course, put it on all. And this is how you know will be notified of all fresh content as soon as fresh content is uploaded and made available for you right here on the platform. The like icon is also in close proximity to the share icon. Drop a like and bust a share. And tell a friend, tell them sister, them brother, them to check out the channel, check out the reasoning, and also join the discussion. The comment section 24/7, it never lack it. Just be respectful and mindful of the guidelines. But other than that, drop your thoughts, your comments, and yes, your opinions there. And we can continue the reasoning via the comment section. Now until the reason again, my sentiments for you and yours, I want to live, love, and prosper. I want to stay tuned.